2024, Mwizerwa Ali versus Uganda.
Susan, Sarah. Excuse me, Russia. I always refer to Susan, but her name is Sarah. Hello, Mr. Amarit Timothy.
My Lord, my name has been murdered, so I prefer to give it life.
Yes.
In any case, you have all the charging authorities. Proceed.
Most of life. My Lord, my name is Timothy Amerit. I am the Honorable Senior State Attorney in the office of the DPP. I appear together with Counsel Zubeda Namugeni. I beg your pardon. Counsel Zubeda Namugeni. From Sania Namugirwan Company Advocates. My Lord, the applicant is in court, and this matter was coming up for hearing by the learned judge. In his absence, my Lord, I pray for another date.
We've appeared in this matter several times. The first time we appeared in this court, Your Worship, the court gave us directives. Those directives were to the effect that the applicant will file submissions.
Now, let us proceed in this manner. The history of the matter is known even for prosecution.
Most of them.
And you are saying file submissions,
Yes.
which is plea on and all parties. Now, I want to give instructions as to how we should proceed as guided by the judge.
Your Worship, we are going to move you under that particular provision of the law. If you're giving us directives, we will also.
The Land Judge indeed is not available this morning, but he has given directives that we have the sureties identified and any other matters shall proceed here. So that's the position and that's how we're going to proceed.
Your Worship, could we add that on the issue of identification of sureties, we could also highlight, since it's for purposes of receiving?
No. Highlighting what submissions?
Highlighting just a few segments of the.
I'm not according to options. I want to hear the take on because of the sureties, period. Those are the instructions, and that's where the legal mandate.
On that note, Your Worship, then we will move to identify the sureties as directed by you.
We appreciate the information that we have received. I need, however, to bring to this honorable court the fact that the hearing of this matter is not an issue of convenience, but one of law. And I've well noted that this honorable court will not take on the hearing of the submissions, which perhaps will be done later. Your Honor, that in my view can subsequently be done with the identification of the sureties in the subsequent sitting. Your Honor, under Section 15 of the Trial and Indictment Act, it governs the hearing.
Under the
Section 15 of the Trial and Indictment Act governs the hearing of a bail application and release of the accused person on bail. And it clearly states that that mandate is squarely of the High Court, and in this instance, the judge sitting as the High Court. The consideration of a bail application, Your Honor, consideration of a bail application, Your Honor, includes one, the applicant lodging the application, the respective counsel either divine being heard on the application, the sureties being identified by the court, and certainly the subsequent determination of the application. Want me to put words in my mouth? We can say you're seated in a court of religious track, simply put. So, my Lord, Your Honor, the High Court is the one to make that determination in a matter of procedure. Now, receiving sureties in the instant case is not a matter of procedure. And it is not even the High Court receiving the sureties, exercising that mandate in itself. It's not the High Court, it's not a sitting judge. Because it is the sitting judge, the High Court, to exercise that right and power. I need not overemphasize, Your Honor, that matters of jurisdiction are creatures of statute. Matter of jurisdiction is a creature of statute and cannot be delegated, not even by an order of court. Matter of jurisdiction is a creature of statute, and it's not delegable or cannot be delegated, not even by an order of court. That would be an illegality. like a high court telling the chief magistrate to handle a murder case. It's an illegality, ab initio. I would wish to draw court's attention to the case of Uganda Revenue Authority. Uganda Revenue Authority versus Rabo Enterprises Limited, Supreme Court Civil Appeal number 12 of 2004, where the Honorable Justice Lillian Tibatemwa Echirikubinza stated that where a court held, I beg your pardon, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandates. Your Honor, I don't see you writing. I pray it's captured even in your report.
Instantly, I asked you to be on the microphone. It's not out of the blue. It's for a reason that you are being captured verbatim.
Most obliged. I hope this excerpt is not expunged. But it says, the